defendant Alec Baldwin's notice of withdrawal of witnesses from the defendant's own witness list. Defendant Alexander R. Baldwin III, by and through undersigned counsel, respectfully notifies the courts of defendant's withdrawal of witnesses from the defense second amended witness list. While the defense maintains the state's motion to exclude defense witnesses, so the state had objected to some of the defense witnesses, probably because the testimony they would offer would be irrelevant, immaterial, not relevant to the criminal charge or any legal defense. So the state had objected to some, but not to others. And the defense is doing some sleight of hand here. They're saying, well, the state had objected to some of our witnesses, so we're going to be nice and pull those back. And by the way, we're going to pull back some other witnesses the state did not object to, just to make things easier for you, Your Honor. So while the defense maintains that the state's motion to exclude defense witnesses is ill-founded and contrary to both the law and this court's order, the defense will consent to the relief sought by the state's motion as to 5 of the 9 witnesses the state seeks to exclude. And then they list 5 witnesses here. None of these names are familiar to me from the Hannah Gutierrez trial. The defense further, in addition to the witnesses the state had objected to, the defense further notifies the court that it will eliminate a further 6 witnesses. And they list several here. Let me see if I recognize these. I guess Gabrielle Gonzalez, was she from the Hannah Gutierrez trial? I'm not sure if she was like the set manager, whatever they call that. John Ziello, that's a familiar name, but the others I don't readily recognize. The defense witness list now consists of a total of 15 witnesses after removing these 6 and the previous 5, so they had over 30. Of the 4 witnesses remaining that are the subject of the state's motion that the state had objected to, the defense stands on its arguments and notes there can be no genuine assertion of prejudice to the state from their timely inclusion. I don't think we need to read about those. Those aren't very interesting. The interesting ones are these 6. The defense notifies the court it will eliminate a further 6 witnesses that the state had not objected to, just in the interest of streamlining the trial. So let's take a look at what the prosecution has to say about this. They don't like it. They want those 6 witnesses that they had never objected to stay on the witness list to testify at trial. So here's their response a couple days after that defense motion. Comes now, the state of New Mexico, by its special prosecutors, Carrie Morrissey and Erlinda Johnson, submit the following response in opposition to the defendant's motion to exclude previously disclosed witnesses. Introduction. On February 6th, the state filed its witness list, naming its fact witnesses as well as its proposed expert witnesses. On March 1st, the defense filed its witness list, naming David Halls as their only witness. On April 19th, the defense filed its first amended witness list, naming an additional 18 witnesses. On May 6th, the defense filed a second amended witness list, naming an additional 7 witnesses, for a total of 26 witnesses. So part of this game, folks, is every one of these witnesses needs to be interviewed by the state in preparation for the trial. So if the defense can add 100 witnesses, why not, to its list? So the state will have to consume resources in interviewing these. Now, I said earlier that when I was talking about CCW Save, that the prosecution has effectively infinite resources, but that's not really true. Here, for example, we have these 2 special prosecutors. If they have to interview 100 proposed defense witnesses before trial, that takes a lot of time to do that. So when we see the defense propose a large number of witnesses and then suddenly cut that list in half, it makes you wonder whether those witnesses were really intended to testify for the defense or if this was just a strategic burning of state resources. So, for a total of 26 witnesses for the defense, on that same day, the state filed its second addendum to its witness list. The state indicated that it was also listing on its witness list any witnesses disclosed by the defense, called as a witness by the defense, or listed on the defense witness list. So I mentioned this at the start of today's show. The state is basically saying, here's our enumerated list of witnesses that we are prepared to call to put the defense on notice, but we have a catch-all at the bottom. And also, every witness listed by the defense is incorporated as a prospective, a potential state witness. The deadline for filing pretrial motions was also May 6th, and in an effort to preserve its right to challenge the defendant's May 6th disclosure of 9 additional witnesses, the state filed a motion to exclude those witnesses. So the state here is saying, we didn't necessarily want to exclude those witnesses, but because the defense filed these additional 9 witnesses on the last day to provide notice, we filed an objection just so we'd have the option of excluding them if we thought it was necessary at a later date. If they hadn't filed that objection, that pro forma objection to these 9 witnesses, they would have forever have lost the ability to contest those witnesses. So the state is saying, hey, this was just a pro forma objection, not necessarily a substantive objection. We were not necessarily saying we didn't want them. We just wanted to reserve the right to be able to say we didn't want them. The state continues. However, the parties continued interviewing witnesses as the pretrial interview deadline is June 5th, which just happened 5 days ago. The state continued working through the weekend of June 1st to 2nd, investigating the statements of the defense witnesses, and concluded that there was no prejudice to the state from the defendant's disclosure of the additional witnesses. So this pro forma objection, the state decided, all right, it's not necessary. We don't have to object. We're fine with these witnesses testifying. Most of the witnesses were interviewed, and the state had been working overtime investigating their statements. Therefore, even though the state initially filed a motion to exclude the witnesses on the deadline, upon closer review and investigation, the state concluded there was no prejudice from the defendant's disclosure. We're fine with these additional witnesses. Meanwhile, realizing that several of its witnesses were actually damaging to the defendant, the defense filed a notice agreeing that some of its witnesses should be excluded. The defendant's motion was not based on a desire to streamline issues or a good faith effort to reduce the number of its witnesses by a significant margin, and as a result, consented to the relief sought by the state as to 5 of the 9 last-minute witness additions by the defense. Instead, the state argues, the defendant's motion to withdraw some of its witnesses was based on the fact that their witnesses actually provided information during pretrial interviews that supports the state's theory of defendant's recklessness and involuntary manslaughter of Helena Hutchins. In fact, during his pretrial interview, Zachary Sneesby told the parties that he positively saw the defendant, Alec Baldwin, pull the trigger when he shot Helena Hutchins. Ouch. Over the weekend, the state continued to work and determined to withdraw its opposition to the defense witnesses. So here the state's saying, hey, we'd already made the internal decision to withdraw our objection. We want these listed defense witnesses to testify. Continuing now, the defense now asks the court to exclude the very witnesses it listed on its witness list, and whom the state also notified on May 6th it could call at trial. The defendant's motion is frivolous and must be denied. The witnesses have been interviewed, and the state timely notified the defense it reserved the right to call any witness disclosed on the defendant's witness list. The defense has suffered no prejudice, and their motion must be denied.